as part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Hello, and thank you for being part of the program today. My name is Tunde Alabi, and the program is Voice, coming to you from our channel, Ben Television. The program is designed to bring to you information about legal matters here in the United Kingdom. Legal matters as it affects immigration, property, investment, students, or even business law in the United Kingdom. Joining us on the program today is our regular guest in-house, Jennifer Obaseki. Jennifer Obaseki is the senior partner at Obaseki Solicitors, a legal firm of professionals based here in the United Kingdom. Today on the program, we will be taking a look at a couple of issues. First will be changes coming to proof of paternity amendment regulation 2015, where it's got to do with a father proving that he is the father of a child in order for the child to access the British right of the father through DNA. That is changes in British nationality law in the paternity amendment that is called Regulation 2015, taking effect come September. We'll also be taking a look at personal injury and power of attorney and a couple of other issues that, if time does permit us to deal with, we'll be taking a look at on the program today. But we can assure you, just sit right back and enjoy the program. My guest, as usual on the program, is Jennifer Obaseki. Let me quickly put this caveat: this is not a legal it's not a legal advice. We're just giving you information that will support you. If you need legal advice, get in touch with Jennifer Obaseki at the address and information that will be brought to you, or the phone line, or better still, you contact your solicitors. Let me bring my guest to you on the program today, Jennifer Obaseki. Jennifer, thank you for being part of the program today.
My pleasure.
One thing about British law is that the law keeps changes every time.
Yes, it evolves, changes, adapts to situations. As with immigration anyway, as the Home Office gets presented with new circumstances and situations, it looks to send in amendments to laws that are already in place. So the amendment that we're going to look at in September is one that the Home Office have had to make because of situations that it keeps being presented with. So of recent, it's become, let me say, popular for people to put down British nationals as a parent on a birth certificate in order for the child to acquire British nationality. From 2007, it's been easy for a person, if they've got indefinite leave to remain in the United Kingdom, or are British, or they've been a European national exercising their treaty rights for 5 years, after giving birth, once named on the birth certificate, then they can apply or fight for that child to then have a British nationality. If the person is British, it's automatic. But if the person is, let's say, a European national or has indefinite leave to remain, then there may be one or two issues, but generally the child will automatically, or should get it. So now, with this new regulation, just simply naming the father on the birth certificate will no longer automatically give the child British nationality. What the Secretary of State has sought to do is to introduce a level of discretion, which means that they can ask questions after the name's been put there. So let's say we put down the name, let's say John Johnson as the father, and he's British, and let's say Kemi is the mother, she's not British or doesn't have status. Then if it's done before September 2015 and the 10th of September, then the child will still get the British passport if the father is British, and there's no other caveat. But thereafter, if John Johnson, after the 10th of September, puts his name down and came and says, this is the father. If they're not married, then what can happen is the Secretary of State may ask that John Johnson provide DNA to prove that he is the father of the child. The significance of this is the Home Office, since the change in legislation in the 2014 Immigration Act, has had a lot of applications from people saying, I'm the parent of a British child. So lots of British birth certificates put forward with a person, a parent, usually the father, saying, I am the father of this child. Automatically, if child applies for a British passport, then mother who is undocumented applies for leave to remain and gets it through the parent route under FLR FP, applying, say, I'm the parent of a British child. So what's happened in, as I say, recent months is when the Home Office has sought to ask further questions on this issue, what has happened, especially when it comes to DNA, and they reserve the right to ask these questions because they are, they've got to assess the applications, and when they feel there's a reason to doubt, they may ask for DNA in the application process. So they've discovered that in a number of applications, the supposed father is not the biological father, and therefore, in order to enable them stop the children getting the British passport, they've introduced this regulation, this amendment regulation, the Proof of Paternity Amendment Regulation 2015, which will now legally stop the automatic issuing of British nationality to a child that's born simply because the father says they are British and they're named on the birth certificate. It allows the Secretary of State that power to then say, no, it's not going to be automatic. Actually, I'd like you to prove the relationship. I'd like you to prove DNA to show that you are the biological father. In the past, and you must know that all family makeups are different. Not family is not just the nuclear mother, father, child. So in the past, where a father knows he's not the biological father and acknowledges that point, but yet says, I accept this child, then what happens is they can normally still accept the child as being part of that family unit and therefore still entitled to obtaining the British nationality. So this new provision is quite significant in that it stops the family unit from determining who, it stops a father who's not the biological father from saying, look, I want to take responsibility automatically for this child. That man would have to step up and say, even though I'm not the biological father, I still take full responsibility for this child. And there are one or two situations that we've had to deal with and have experience in dealing with this particular issue. And the Home Office, I would say that given the number of cases that they've come up with this recent application of FLR, FP, and let's say people applying on the basis that they are the parent of a British child, I think they didn't expect the number of cases. The same with the changes that they made after the wave of EA dependence. They've had this wave of applications and they're thinking, how do we further analyse and assess these applications? And then they've discovered, when asking parents to go and do or provide evidence of DNA, that some of these fathers are not the biological fathers. So now how do we stop those children from getting British passports, you see? So it's an interesting development. It's an important development for our community so that we can see how best to advise families, especially where there may have been a breakup and there may have been a situation where the father is not the biological father, or the father accepts that he's not the biological father but wants to accept the child. So we have to be prepared to deal with those types of applications and how best to advise the families, really. It's not always the father, it can be the mother in a situation where the mother believes that there's a situation where she's put down one person's name as the father and may not be sure. There may be a situation, there's multitudes of situations. We've had situations where people have presumed themselves to be the father on entry clearance applications for years. Maybe the initial application refused, only going towards an appeal is it discovered that they're not the biological father for the child, which is difficult, a very difficult situation. If they've been estranged for some years and there's been explanations from one party or another as to why that's not the child is not biologically the man's, and yet they've decided to stay together, or they've gone on to have further children, and so the father then decides that, okay, I'm going to accept that one. Then you see the family may need such detailed and intricate submissions on that point that it's very important that you take detailed, comprehensive legal advice on your situation. Don't presume or assume that, oh, just because this person is not the biological father, that's the end of the road. If you are in a genuine relationship and the gentleman has decided to take on board this responsibility, then you have to really take advice on how best to present your application for not just nationality, but present any further application on to the Home Office. The fact that it's discretionary doesn't mean that it's a no. The fact that the Home Office will look into it is what this provision, this amendment gives them. It gives them that power. It's no longer just automatic.
Okay, all right, what that implies is for people who are looking to use such a situation, they've got to do this as early as possible before on the 10th of September.
Yeah. You know, before, you might have the wrong person named on a birth certificate and then seek to have it changed. You'd have to make an application to the registrar to change anything on a child's birth certificate. So where you don't put somebody's name, you leave a father's name off. If you're a British mum and you leave the father's name off because you've fallen out, you don't put the name there. Or you're not married to the person and you decide they don't follow you to the registrar to put their name on it, the birth certificate. There's those situations. So sometimes the father's name can be left blank. It's the mother that really takes responsibility for registration. If you're married, you might not even have to have the father with you. So you can go along to the registrar with a marriage certificate, the baby, proof that you've given birth to the baby, and so far as you've got your marriage certificate there with you, then the registrar has to put the father's name on there. And you can also see that if you have a marriage certificate from abroad, it creates a situation where the registrar may not be familiar with the marriage certificate, but may want to do further investigations, and the power has been given to them under the 2014 Act to actually carry out further inquiries, and an obligation on them to carry out further inquiries, in fact. So again, if your situation is not straightforward, please get advice. And if you are having to register a child and you have issues with regards to the paternity, again, if the father is fully aware of those issues, take advice. Don't think that because of these amendment regulations that it's going to be rejected. It means that the power of the Secretary of State is discretionary. In other words, you have to convince the Secretary of State that it's reasonable for your child to have that birth certificate and be given British nationality.
Okay, all right. We've been taking a look at changes in British nationality law as regards paternity, proof of paternity amendment regulation 2015 that will come to effect from on the 10th of September. If you're looking to go through these rules to have your child become British citizen based on the father's nationality, well, if your due date is anything after September 10th, you may have to get set to prove, the father may have to get set to prove the real paternity of the child through DNA, if that's the if there, if the Secretary of State feels, well, there's a need for us to prove the paternity of the child. That does not mean you're going to get a letter from the Home Office to say, look, the father should come and prove the paternity, but now it's become a kind of a law
giving them the right to ask you that.
Yes,
so they've now acquired the right to ask you to go and get it, whereas before they didn't have the power to ask you.
Fantastic. All right. That is proof of paternity amendment regulation 2015. Anyway, if you fall into that category and you think something may be wrong at some point, that's not the end of the road. Like Jennifer did say, get advice, get a good solicitor to look at your situation, to review your situation. Of course, there are human beings at the Home Office, there are human beings at the different tribunals at appeal stages, and depends on how you're able to prove your case. Then you might be able to have your way through. That is on the issue of proof of paternity amendment regulation 15. We'll keep giving you more updates as situation emerges, but we can tell you there are much more today. So many homes are most likely to be put in the salary, because so many men will think they are probably the father of a particular child or children, and DNA will come out, they find out that, of course, there's an issue that about 6% now are actually falling victim of this irregularity in paternity DNA.
Yes, in America it was about the same statistic. About 6 out of 10 fathers were proven not to be the biological fathers of their children when it came down to maintenance suits. So this is when the initial home testing kits came out, and they took a survey of those who had undertaken the test, coercively, only to find out that quite a large number, staggering 60%, were not the biological fathers. And those men then later went to go and challenge the maintenance orders that they were given at court, given the fact that they only went through with them because they thought that they were the biological fathers. So now that DNA testing is widely used, it's something that the numbers hopefully will be more reflective of what should be the case, as in 100% of dads should be known to be the biological fathers of their children. But on a serious note, let's say, the numbers have stacked up at the Home Office, and that's why we've got these changes. As I said, the Home Office legislation changes according to what's happening in the society, and they've seen the need to put this change in place and give themselves the power to ask people to provide DNA samples. Okay?
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
A lot of people who are involved in injuries at work, at home, in places, and they actually do not know what to do, maybe for lack of knowledge about the steps they need to take, or for lack of proper advice as to what they need to do, or fear of what legal charges should be. Jennifer, you want to quickly take us through personal injury and power of attorney? If you're watching this program, if you've been injured at some point, you may find this very necessary and important for you.
Well, the first thing to do if you've been injured is to get help for your injury. That's the first thing that you must do. And depending on where and how you've been injured, it's important that you try to collate facts. If you're in such a state that you are not able to take down the names of witnesses, further details such as location, whether the person has insurance, whether the person has had training, etc., then the one thing that you must do is you must get help, and then you must have at least some basic information to take to your solicitor. So, for example, it's difficult when people come in to see us and say, oh, I had an injury on the bus, and I can't even remember exactly what time the bus was, what number the bus was, what street the bus was on. But these things happen. So the first thing is, one, get help, and then we have to then look towards getting a record. So the record may come from witnesses. If it is possible to get the names of people who've seen things, then you get them at the scene. If not, you may have to follow up and see whether first responders who have attended the scene took down names or took down any further details that may help you. But the main important thing for people is to know that there is a time limit. You can't come more than 3 years after an incident and expect to get full compensation. The court has discretion to look at your case and say, okay, there's a good reason why this person didn't initiate their claim within 3 years of the incident. And the incident we're talking about the day of the accident. So your time starts ticking rather, from the day of the incident, and you must bring your claim within 3 years of having that accident or injury. The difficulty that you have is sometimes people don't know they've been injured. There's one situation where, let's say you suffer a brain injury and it doesn't manifest itself on that day, or it manifests itself after the 3 years or into the second year. You start having headaches. You don't realize that those headaches have started as a result of a trauma to your head. You don't realize that until maybe after you've been referred to this neurologist, and the neurologist therefore then tells you, oh, have you ever had a head trauma? And you say, oh yes, way back when. So sometimes there may be situations where the court can overlook this rule, this limitation, and look to allow you to bring your claim after 3 years. But it's rare. Don't rely on it. Please make sure you take action in time. The circumstances as well, and people's liabilities, don't assume that you may not get something. So again, when people have common injuries like on the bus, or when they fall at an airport, or they trip somewhere and they think, oh, that's just nothing, Jared, then they don't realize later it's only when the injury is diagnosed as something very serious. It's like, oh, this thing happened when I tripped way back when, but you didn't take action. The best thing to do is to always try to record any accident or injury. If you're in a public space, try to make sure that an official in that public space is aware of it. So you go to the first aider, make sure it's put in their incident book if it's in a public building, or even in a commercial premises, or as I say, even in an institution. Just make sure if there has been a cut, something that you might see as minor, just make sure that a first aider is aware and it's recorded. Again, if you're handling a child and the child is injured and maybe you don't pay attention to the child, you're rushing somewhere, you don't realize that that trip or fall may be actually a fracture or something like that, there may be further obligations to that child depending on where you are and who you were with, as to whether there should have been further care and attention provided for that child. So for example, if you go into a shop and there's some colourful things near a hazard, so there's some balloons near a place where there's a large gap, the fact that the people who are running that establishment should have anticipated that a child would be attracted to those colourful objects there. There may be further obligations in negligence with regards to that type of situation. So these are just examples that I'm giving you. So the main thing is act in time, make sure that you can get as much information as possible, and also make sure you can get as much records as possible. So whether it's from the place, whether it's from third party that attend the place, so if it's first responders who get back to the actual scene to attend to you, see if the police or paramedics actually have recorded names of witnesses or anything like that. It's quite important to do. So after you've done all of that, the other main thing is to actually get legal advice. Do not think that you can run something as complicated as a personal injury claim on your own. It's important that you go to somebody who is experienced. The fact that many people, let's say, want to put themselves out as solicitors but not yet be specialised in a certain field is very, very bad. You can go to very big law firms who specialise in this one area, or you can go to specialist firms who specialise in litigation, who'll be able to give you a detailed advice as well as anybody who specialises in the area, so far as they've had enough years of experience practicing the area.
If you're watching this program, you've got any query, you've got any question, do send us an email, or you can call the phone number straight on your screen. That phone number belongs to Jennifer Obaseki's firm, and they will be able to speak to you. Or better still, you can get in touch with any solicitor of your choice on
Law Society
website as you deem fit. But better still, you can send us an email to galab@yahoo.com. You can follow us on Twitter, Tunde C3 at Tunde C3, or better still, just call the number on your screen that belongs to Jennifer Obaseki Fem. Then they'll be able to attend to you. This is how we can go on the program today. It's been nice. Take a look at this hot topic. Most importantly, changes in British nationality law as regards paternity, and that's got to do with proof of paternity amendment regulation 2015. If you're looking to give birth before on the 10th of September, and you're looking to have your child taking reference after a British father, you might be preparing to have the man do a DNA to prove the paternity of the child before the Home Office. However, you might be lucky. The Secretary of State might not be bothered at all. After September 10th, and also if you're injured, then you think you need some compensation to get expert advice. My name is Tunde Alabi. It's a pleasure having you on the program today. Do stay out of trouble until we come your way again. Enjoy the rest of your week. Bye. As part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.